Hey everybody, welcome back to another week of Law, Politics, and Society. I hope you all are doing well and keeping safe. This week we're going to look at the limits of social control and the process by which the criminal justice system polices vice. Vice crimes are really interesting because we often see that there is a lack of social consensus around whether or not vice crimes should actually be in the criminal code. So these are some things to think about as we go forward this week.
So what is a vice crime? Well, they've been referred to by many names. The most common is a victimless crime, but other words for them are nuisance offenses, consensual offenses, and public order offenses. Vice crimes vary significantly across different cultures and across time. So what has been constituted as a vice crime in, say, the 19th century may not be today. And so we're going to talk about the historical overview of vice crimes a little bit. Modern criminalization has moved away from conceptions of morality. That's where vice was originally based, was crimes against the moral order, or the idea of what was morally acceptable. And there is debate about whether these crimes should be legalized, if there should be any laws surrounding things like pornography, obscenity, prostitution, and illegal drug use. This is because most vice crimes are consensual. They involve participation because of reward or pleasure. People want to participate in them, and they're seen as harmless. And that's where the vice crime rubber really meets the road, is when you can understand whether or not there's a social harm. And is that harm demonstrative enough? Can we demonstrate that that social harm is enough? And this is why states such as Oregon and Washington have started to legalize marijuana, because they believe that the harm is not great enough, that it's no more harmful than, let's say, alcohol or tobacco, and it's a choice if you want to engage in those substances. And so we're going to talk about how those decisions are made and how the tide turns in those debates. So alcohol has been understood as a vice crime, but it wasn't until really the early 19th century, when the Massachusetts Society for the Suppression of Intemperance first formed. And this was the first real push to prohibit all kinds of alcohol for health and moral reasons, to stop the decay of the family, to try and alleviate poverty. And you've seen a lot of this in the documentary I had you watch. Initially, in 1657, there was a prohibition on really strong liquors in Massachusetts, but it didn't last. And this is because beer has been so historically part of American culture since its founding. Beer was often safer to drink than water, but it was significantly less potent in its early form. And this is why it is something that is still considered quite dangerous. Of all the substances that we see, alcohol is the one that's most directly linked to crime, because we see so many individuals who have committed their offenses while impaired on alcohol. At least 70% of American prison inmates reported that they were abusing alcohol at one point or another. And so that's a huge amount of alcohol-related arrests and alcohol-related imprisonments. So you can understand why the Massachusetts Society initially tried to limit and curb alcohol use by attempting to make it illegal. So I'm not going to spend too much time on looking at alcohol regulation because you saw a lot of it in the documentary Prohibition that I had you watch, but I'm going to go over a few key points. One of the first ones is that Kansas was the first state to outlaw the sale of alcohol in 1881. And from there, we really had the movements that we saw, the Temperance League, primarily led by women, to pass the Volstead Act and the 18th Amendment. So these two combined are what constituted prohibition, and it prohibited any intoxicating liquor containing more than 0.5% alcohol. So this was the law of the land for about 10 years until we started to see the stock market crash. And with the Great Depression, we start to see a lot of changes in enforcement, in how strictly people are buying into the regulation. And it's so expensive for the government to enforce, there starts to be wide-scale mobilization against the 18th Amendment. And really, it came down to an economic argument. It was too expensive to enforce. There weren't the resources that were going to be necessary to ensure that could be fulfilled. And so in 1933, the 21st Amendment repealed the 18th Amendment, and it was the first and only amendment that was repealed by the ratification of a subsequent amendment. One of the important harms to talk about when we talk about the role of alcohol is fetal alcohol spectrum disorder, or FASD. This is a neurological category of disorders that result from mothers who consume intoxicating substances while pregnant. And this can result in anywhere from minimal impairment to incredibly severe impairment. The prevalence for this is about 1% of live births in the United States, which is fairly high compared to other Western countries and developed countries. It frequently results in identifiable physical abnormalities and behavioral symptoms. And what we see is that there are criminal elements, criminal behaviors, or prototypes for criminal behavior, independent of FAS, irrationality, lack of understanding of consequences, poor judgment, prefers instant gratification. All of those things independently are risk factors for criminality, but individuals with FASD frequently have all of those risk factors. And so it means that these individuals wind up having a much stronger likelihood of interacting with the criminal justice system. So when we talk about illicit drugs, what has been understood or defined as illicit or criminal in the substance world has changed greatly over the last 200 years. Many of you will be familiar with Sigmund Freud and his propensity to both use and prescribe cocaine to his patients. Cocaine was famously one of the main ingredients in Coca-Cola. It was marketed as a stimulant, and it wasn't known to have the addicting properties and the harmful quotients that we now understand until much later. This is also true with things like methamphetamine and amphetamine salts more generally, as these were marketed to housewives to cure boredom in the 1950s and help them achieve their mundane, boring tasks more easily. And so our understanding of illicit and deviant substances has really shifted. And again, it's been mostly about conceptions of harm. What does harm? Not just to other individuals or to individuals themselves, but as a society. And so we've changed our gaze subsequently as we've understood the addictive powers of some drugs. And I think we are in the middle of another reckoning with this, particularly on the one hand with the legalization of marijuana, but on the other hand with the powerful addictive properties of opioids and prescription painkillers. And we've seen the damage that has been done from things like OxyContin and oxycodone. One of the acts that set the standard for these changes were the Harrison Narcotics Act of 1914, which changed the landscape for how drugs were going to be regulated, who was going to be able to distribute them. Initially, it was primarily interested in heroin and drugs that were primarily coming in from the East Orient. And they were regulating and taxing production, the importation, and distribution. So the federal government wanted to make sure it got paid, as well as the individuals who were selling the drugs would get paid. But by the 1920s and the rise of the Roaring Twenties and the culture of excess, addicts started to be viewed as deviants for using drugs for pleasure. This was tied in with the temperance movement and the idea of excess and pleasure as sinful. And so the Narcotics Act initially reduced the number of addicts. The drugs were harder to get, they were more expensive, but it created a black market and ultimately created more addicts with less infrastructure to deal with the consequences. One of the things that we now understand about illicit drugs is that they tend to hijack the brain and have much stronger impacts on pleasure centers than alcohol. And so this creates a potential for illicit drugs to be more harmful than alcohol. Certainly, things like amphetamines, cocaine, and heroin are seen to be more of a problem because they're reacting to this pleasure center in the brain. Using drugs doesn't seem to necessarily initiate a criminal career, and in fact, most of the time, people turn to criminal careers to support their drug addictions. So it's not that they have criminal careers before they start using, it's a product of the use, and it's largely driven by the illegality. The fact that it's illegal drives it underground and creates black markets where the criminal justice system can't reach oftentimes, and creates these networks of illegality. And often criminals who engage in things like drug dealing, drug trafficking at much higher levels are not the ones who are addicts. Addiction is fairly rare, actually, for most drugs. It's about the same likelihood as becoming an alcoholic. So there are genetic factors, but certainly everybody that uses drugs doesn't become an addict. And most dealers and high-end distributors don't use drugs. They see themselves more as empire builders or moguls who are creating these distribution networks. And with that often comes violence. And so we see violence to control territory, we see violence to expand territory, and this is frequently seen as a part of doing business. And this is more often with the traffickers than the users. We see this in the United States quite prevalently. Drug violence escalated into gang wars, particularly in the 1980s, where we saw Los Angeles become a hotspot for drugs, particularly crack cocaine, that had been imported in from Central America, and the effect that that had primarily on the inner city as a result of the Tough on Crime and War on Drugs initiatives. In 1988, approximately 80% of the homicides in Washington, D.C. were drug related. And so it shows you how seriously people take this industry. The drug industry makes billions of dollars a year illegally. It's one of the biggest industries next to human trafficking in the illegal criminal world. And there's a direct link between the dramatic increase in homicides in the 80s and the emergence of crack cocaine. And so we saw that dealers were taking over new territories, they were controlling their territories and intimidating rivals using violence. So what do we do with the criminalization or the legalization of illegal drugs? Well, the federal government criminalizes drugs and has strict regulations as to individual drug categories called schedules. So, for example, marijuana is a Schedule 1 drug, which surprises many people because it's the same class as heroin. So, obviously, they view marijuana much more seriously than some states do who have legalized it. And this creates a very strong tension where doing something legally in a state is actually illegal in the eyes of the federal government. And so the federal government, for example, has exclusive jurisdiction over things like interstate commerce, which means that you can't use highways to transport the product without fear of being prosecuted. You can't use the IRS and banking the same way. I'm going to include a video that John Oliver did about marijuana to just show you the insanity of this. And there's never been a Supreme Court case that has decided whether the states can legalize or criminalize certain drugs independently of the federal government. And so it will be interesting to see if that's something that we see as the new frontier of legalization moves forward. We now have begun to understand that the war on drugs has been more of a cause for harm than it has prevented. It incarcerated hundreds of thousands of people for nonviolent offenses, things like possession, and removed and shattered communities and families. Most countries have abandoned their war on drugs long since, and the US is lagging behind in its public policy as it relates to addiction and understanding addiction. And one of the things that most countries do when they abandon the war on drugs is they move to what's called a harm reduction approach. The goal of harm reduction is to allow individuals who have addictions issues to to treat those issues while still using the substances, but avoid all of the unnecessary harms that go around with that. So, for example, harm reduction can advocate and create programs for safe and clean needle exchanges, or even have nurses monitor drug distribution and drug injection to make sure that there are no overdoses. They can supply drugs at a rate that allows individuals to not have to steal to be able to afford them. It can create drug substitution programs, such as we've seen with methadone, to decrease symptoms of withdrawal and allow people to try and resume, their life before drugs. And the biggest thing that you can do is decriminalize use. The biggest example of decriminalizing is in Portugal, where they have legalized essentially all drugs. The Netherlands has done that to some extent. They've kind of gone part way. Recently, Canada obviously legalized marijuana, and we do have harm reduction approaches, but we haven't gone so far as decriminalizing all drugs. But the United States is one of very few countries who have really pushed back against a harm reduction model, and has continued sort of the incarcerate, punish, deter model, which so far hasn't worked, and all of the evidence shows won't work. But there hasn't been this push, other than the First Step Act, which was passed at the end of 2018, to try and change the framework in any meaningful way yet. One of the other vice crimes historically, which has changed, was sodomy. So sodomy is anal sex between two men or between a man and a woman. Although most anti-sodomy statutes in the United States were really only interested in homosexual sodomy, so engaging in anal sex between two men. And this led to, this law came out of rampant fear and misunderstanding of homosexuality. Throughout history, gays and lesbians were marginalized at best and subject to a number of labels at worst, including diseased, psychotic, and schizoid, part of a group in the American Psychological Association of psychotic, paranoid, and schizoid disorders. They were seen as moral flaws, and subject to shock treatment and castration and conversion therapy, among other attempts at changing their sexuality. And it really only started to change in 1973 when the American Psychological Association removed homosexuality from their list of mental diseases in 1973. And this led to two major court cases. The first is Bowers v. Hardwick in 1986. And in Bowers v. Hardwick, you finally have the Supreme Court recognizing that sodomy was a crime. They acknowledged that the state had the right to criminalize sodomy. But they said that there was a bona fide rational state interest in served by the sodomy law. And this was largely because of the AIDS pandemic. Moral inclinations trumped constitutional law in 1986 because people still believed that HIV was primarily a gay man's disease. And in fact, it was originally called GRIDS, which was gay-related immune deficiency syndrome. And so the first time that the sodomy statute goes to the Supreme Court, it's not successful. And this is true all the way until 2003, when 18 states still had laws on the books forbidding consensual sodomy. And Lawrence v. Texas was a Supreme Court case that went all the way up that finally said that the laws surrounding the bedroom, what goes on in sort of the bedroom of the nation, and the regulating that was unconstitutional. And so in a 6-3 majority decision, they said that the laws banning sodomy were rejected. They needed to be rejected. And this has brought the US in line with other Western democracies. And so all of the sodomy laws on the books in 2003 were struck down. And so they are no longer valid. One of the things that often gets brought up in the discussion of same-sex rights and the evolution of same-sex rights is religious liberty. And this has been a two-part sort of revolution recently with regard to homosexuality. This is because initially individuals who identified as gay or lesbian, bisexual, or transgender were classified as diseased. And we've moved from that to understanding that they are a quasi-protected category. And we have seen the shift through some major cases. The Civil Rights Act of 1964 didn't explicitly protect gays and lesbians, but some have incorporated that act to grandfather protections in for the LGBT community. But the major cases that allowed this development were the United States v. Windsor in 2013 and Obergefell v. Hodges. So in United States v. Windsor, the Supreme Court struck down the Defense of Marriage Act, which had been passed under the Clinton administration, that explicitly defined marriage as being between a man and a woman. And this allowed for the Obergefell v. Hodges challenge. This came out of a ban that a state had on same-sex marriage. And so you have the plaintiff suing the state saying you have no right to ban same-sex marriage, particularly in the light of the Windsor decision. And the Supreme Court agreed and said that the ban on same-sex marriage was unconstitutional. It didn't create a right to gay marriage, as you will sometimes hear people say. That is absolutely not true. There's no right to gay marriage in the United States. But it is unconstitutional to ban gay marriage. And that is a very different thing. But there are concerns for some dissenting justices in the Obergefell decision for what it would mean for religious liberty. There was concern that individuals who did not hold the same religious views or individuals of religions that believe homosexuality is a choice would be vilified or ostracized. And so there is a balancing act that the state has to try to tread here between the rights of the LGBT community to not be discriminated against, to not be experienced certainly harassment or any sort of victimization, but there's a right for the religious communities to believe what they want to believe without intimidation. And the courts are reconciling these tensions. And as with all freedoms, there are exceptions. And the First Amendment, as we've talked about before, is not different to that. The government can interfere with religious practices. That was set out in Reynolds v. United States in 1878. And it can mean that the government may require individuals to do things that they may not like, even if it hurts their religious beliefs. And we're going to talk about that a little bit on the next slide. So in order for the government to infringe on any right, any constitutional right, they have to demonstrate that they have a compelling state interest. So that's the acceptable standard for weighing whether or not the government has any business interfering with a freedom, such as religious liberty. What is or is not a compelling state interest often gets defined from case to case. It is usually context specific and typically involves things like engagement in actions that were contrary to criminal law or could hurt or endanger others. For example, if a religious group did not want to serve a group of gay individuals at a restaurant because it went against their religious beliefs that gays should eat at restaurants or that they should serve gays, you could have a lawsuit stem from that. And we have seen this in a case we're going to talk about in a minute, in the Hobby Lobby case, but also more recently in a Colorado bakery case called Mastercraft Bakery, where you had an individual who refused to make a wedding cake for two gay individuals based on his religious beliefs, and they sued, arguing that they should not be subject to any discrimination that any other person would be subject to. And so there is a balance that needs to be struck. And And this hasn't been limited to religious organizations. Initially, people thought maybe it would be limited to things like contraception and access to contraception, but it has seemed to involve small businesses and communities and has resulted in this collision of rights that appears sometimes to create these irreconcilable demands of other rights. One of the other interesting cases that deals with this issue is Kim Davis, who I had you read about. Kim Davis very famously refused to issue marriage licenses to gay couples after the Obergefell v. Hodges decision, and she was held in contempt of court. She was ordered to issue those marriage licenses by the state and the justices in the state court, and she refused. And so she was incarcerated for a period of time until she was ordered again to comply. And eventually, they reached a solution where her signature would not directly have to appear on the marriage license. She did not believe in gay marriage for religious reasons and did not want to sign off approving gay marriage. And so they removed the signature part from the license, which then she accepted as a condition and returned to work. And so the issue has often been framed as a refusal to serve gay and lesbian individuals because it contravenes either religious identity, and it has become implied that businesses that are owned by devout religious individuals must face this tension between either violating their identity or legal penalties. And so this is where we get the Hobby Lobby case. So Burwell v. Hobby Lobby Stores is from 2014. This will be the Hobby Lobby that you are familiar with. And the decision points to an attempt at a solution for mutual protection, saying gays and lesbians have the right not to be discriminated against, but businesses have a right to decide who they want to serve and not to have their religious beliefs jeopardized. And so there's these sort of tensions in standards that the Supreme Court tried to flesh out in the Hobby Lobby case. And so what we saw in Hobby Lobby was the court holding that closely held corporation owners, so corporations that aren't national conglomerates like Walmart, or where you have very distant ownership, but ownership of a company directly by individuals who have very strong religious beliefs, have religious rights under what are called the Religious Freedom Restoration Act of 1993. Now, states have also passed Religious Freedom Restoration Acts. Those are separate from the federal Religious Freedom Restoration Act. And the government has said that closely held corporations are businesses with that are owned by 5 or fewer individuals, and where the owners have more than 50% of the value of the stock. And so when you have individuals who are in that situation, they do not have to provide contraception, for example, because they believe that it is or could be essentially inducing an abortion or helping to end pregnancies, like things like morning after pill, and that contraception should not be prevented. And so this is a belief in some religions. The court tried to adopt what they call the least restrictive means test to try and balance the rights of the company owners to not have to violate their beliefs and provide contraception when they don't want to, and the individual's rights to be able to exercise their own reproductive freedom. And so the tension here is changing frequently. We see the development of these Religious Freedom Restoration Acts in states, and it is likely that we will have another one of these cases eventually go up to the Supreme Court to try and see what balance can be struck. Religious Freedom Restoration Acts mandate that strict scrutiny review is the type that has to be used when determining if the free exercise clause has been violated. And so this was passed as a barrier to the growing sort of government involvement in religious liberties. And so religious liberty is one of the most protected tenets of the core rights in America. And there have been other companies that have discussed um, litigation or potentially pursuing a case that would be similar to the Hobby Lobby Burwell case. Um, they, in your text, they go over a few other independent businesses and shops who have been forced into attempting to serve individuals whom they do not agree with their religious beliefs or do not agree with their lifestyle or who they are. And the court has consistently said that you have to use strict scrutiny and that the least restrictive means test is only going to be applied when there's a clear demonstration of this infringement on religious liberty. The next area I want to talk about when we understand vice crimes is prostitution and more commercialized vice like gambling. So the earliest writings regarding prostitution were contained back in the Code of Hammurabi. So we've talked about this before. And prostitutes enjoyed something of a privileged status, which seems hard to reconcile. We're talking about something that was seen as immoral and illegal, but yet these women, and for the most part, by and large, they were women, um, were seen as engaging in sort of a profession. They were allowed to be in temples, they were allowed to make offerings, and we see references to prostitution even in texts like the Bible. So you could become a high class courtesan or a high class sex worker even in ancient times. It's been considered a necessary evil throughout American history, particularly as it related to the American Revolution, where the sexual needs of the troops were tolerated and where it's argued the term hooker came from, all the way through to the Old West, where sex work was particularly active in the frontier period. You see a lack of the grip that the Victorian era had on more of the East Coast and a push west where women were rare, and so they could make significant money engaging in sex work. But there were some concerns with prostitution, particularly the fear of venereal diseases and the rates which venereal diseases were infecting and spreading. And Victorian morality, this sort of very stiff, strict sense of morality, started to clamp down on viewing sex work as indecent and unacceptable. And the White Slave Traffic Act of 1910 actually prohibited white slavery, and it was a felony to transport women across state lines for what were called immoral purposes. And this is where we see significant changes in judicial enforcement of sexual norms. So we have these changes all the way through the 1940s, which become much more strict. And this is illustrated by Mortensen v. United States in 1944, where you have individuals who live in Nebraska and are running a brothel, and they had traveled to Salt Lake City accompanied by some of their sex work employees. It was a vacation, no evidence other than a vacation, but they were all convicted in district court. And the U.S. Supreme Court, for the first time, overruled the convictions, saying that they were improperly charged under the Mann Act, and that they should not have been subject to persecution because they weren't engaging in white slavery. They weren't engaging in prostitution. They were going on a vacation to visit family. And we really had sort of legal silence on the issue of prostitution from the courts until Roe v. Butterworth in 1997. And so this is when you have an argument that prostitution laws, the laws that prohibit selling sex for money, are a violation of the right to privacy, and that individuals should be able to earn a living however they choose to earn a living, particularly if it's not harmful to others. So Roe tried to use the Ninth Amendment protection, but the Florida Supreme Court said, no, that doesn't fall under how we understand privacy. there's more of a rational reason to prohibit prostitution, particularly to protect the sanctity of marriage. And so there was no change on the laws more broadly. But the question has remained, are the harms of prostitution real? Do they affect people enough to warrant state interference? Why are we regulating this? Nevada has legalized sex work in counties that are under 400,000 people. So not Reno and not Las Vegas directly, but otherwise prostitution is legal in Nevada. And if you legalize it and regulate it, you can alleviate some of the fears like the spread of disease. But there's always a fear that it's too closely related to the drug market, that individuals are engaging in drugs while they are either buying or selling sex, which again, you could regulate if you wanted to. You could make people take drug tests. The big fear that, however, is human trafficking, and that you're not just going to get people who are participating for their own free will, but you will get people who are brought in and trafficked to work in sex against their will. So there have been two arguments moving away from the criminalization of prostitution. The first would be the decriminalization, which would remove all laws against prostitution, but it wouldn't impose any regulatory frameworks necessarily on it. And the other is the legalization model, which is the Nevada model, where you regulate, you tax, and it becomes a legitimate occupation. You can have health and safety laws the same way you would have for any other business employee. And there are three other models that have been experimented with lately. The Netherlands legalized prostitution. The customers, the prostitutes, the procurers, pimps, everybody's legal as long as they remain in the areas that they're supposed to remain in. There's prescribed areas, so certain brothels. You may be familiar with things like the red light district. The downside is that most of the individuals working in the sex trade are from poorer countries. They have moved to the Netherlands to engage in the selling of sex. And it's hard to know who does that voluntarily and who has been trafficked. And so this is the big fear, is that most people that will end up working in this industry are immigrants from other places at best, or victims who have been trafficked. The United Kingdom has a different approach. The United Kingdom has moved towards a decriminalization model where women are not penalized for selling sex, but all third parties, any way to live off of the avails of prostitution. So pimping is illegal, procuring is illegal. They're not allowed to solicit on the street, so they have to use sort of high-end hotels, or they have to sell, in other ways. But they also can't work for a brothel. So there's all of these rules and regulations that are cumbersome and difficult to enforce, and may not necessarily address all of the issues. Sweden has also decriminalized prostitution, but they've maintained laws criminalizing the purchasing of the services. So they will never arrest the prostitutes, but they will arrest the Johns for buying sex. They don't arrest the sellers, they arrest the buyers. And that is something that has been seen to be controversial. The goal is to deter, to essentially say, okay, if people are going to get arrested from buying sex, then people will stop selling it. It hasn't worked. There's no evidence to support that it's worked, but it has at least suppressed the number of sex workers who have been arrested. And as you saw in the readings, there are numbers of women who enjoy sex work, who want to do sex work. It's not a profession for everybody, but there are people that choose it. And the line of what's sex work and what's sugaring, a sugar baby, sugar daddy relationship, is really blurry. And so I'm really curious to hear your thoughts about that in discussion this week. I'm not going to go through all of the tests for obscenity and all of the obscenity and decency laws. You don't have to know all of them. You should just be able to define obscenity and indecency. So I'm going to leave in some of these slides that I created about obscenity and indecency and the regulation of them if you want to learn more. but I'm not going to narrate them. So make sure you download the PowerPoint so that you can see the next few slides, because otherwise they will be skipped through on the video. One of the things I do want to focus and touch on this week, however, is the conversation surrounding abortion. So abortion is one of the most hotly debated topics in Western society, and it really seems to divide modern America. When prohibited in the United States, it was considered a vice crime, but it really doesn't fit the standard definition because consensual and victimless are really problematic terms when you're dealing with, for what pro-life advocates argue, is another human being. They argue that the embryo or fetus or potential human is a victim and that the terms consensual or victimless can't possibly work for the maiming or killing of something that could have been a human. And so long as women have become pregnant without a committed partner, abortion has been sought historically for numerous reasons. It's been around since ancient Greece, and views of abortion have largely fluctuated across centuries and cultural norms. The first regulatory laws on abortion, again, we have to go all the way back to our favorite Code of Hammurabi, where you have some very, I would say, moderate restrictions on abortion. You have the belief that you could fine women for causing miscarriage, but it wasn't sort of acted on the way that we think that would be today. And today there are laws that fine individuals for inducing miscarriages in Central American countries, and those are enforced much more strictly and much more severely. In the Middle Ages, up until the early 19th century, the Roman Catholic Church prohibited abortion under any circumstances, for any reason, for any of its members. And except in, from after the point of quickening, after about the 3-month mark, most countries sort of said, no, we're not doing this anymore. We're not allowing it, not just with a fine. This is more serious than that. So the attitudes changed, and the attitudes towards those who were actually performing the abortion were more severe, because there was some understanding to the women who were in dire circumstances, who themselves had perhaps been sexually abused, or were in poverty and couldn't provide for a child. But there was far less forgiving for people who were procuring abortions, because it was seen that they didn't need to be doing that they were helping the evil that was being spread by this commission of this crime. But there starts to be a turn, and the turn is at the 20th century. Initially, every state prohibited abortion except where the carrying of the fetus put the woman's life at risk, but enforcement was slack, and so many abortions were performed by sort of shady clinics, back alley clinics. You could sometimes find what was called a reformed physician, and they could be performed by those claiming to have experience, but this resulted in huge numbers of deaths and grievous gynecological injuries from individuals who pretended to be doctors and weren't, or didn't have experience and didn't know what they were doing, because this wasn't taught in medical school. And so the number of women who are dying every year from attempted abortion or attempted inducement of a miscarriage was really, really high, and the government recognized it needed to do something. So by 1973, 17 states had amended laws on abortion, allowing for abortion at least in certain conditions such as health risks, incest, or rape. But most had very restrictive laws still. Most states had very restrictive laws. And this is where we get probably the most controversial decision in US Supreme Court history with Roe versus Wade.
So in Roe, the US government was asked to decide whether or not a woman should be allowed to have access to abortion, or if the ban on abortion in the state that Roe was in at the time was constitutional. And what the Supreme Court said was that the ban on abortion the complete ban, was unconstitutional. That there was a right under the Ninth Amendment, the right to privacy, to abortion in certain circumstances. So women could have an unlimited right and unlimited access to abortion in the first trimester, allowing regulation in the second trimester, and prohibiting it in the third trimester unless the woman's health was significantly at risk. And in Doe v. Bolton, which was argued the same day, they clarified the regulations in the second trimester and third trimester by essentially saying a woman may only obtain an abortion after the fetus would be viable outside the womb, only if necessary to protect her health. So the Supreme Court tried to strike a very delicate balance by stating that yes, abortion would be permissible up until the 3-month mark, and after that, it would be fairly significantly regulated, and particularly after 6 months, it would be almost impossible to get. So ever since the Roe and Doe cases, the Supreme Court has been trying to fine-tune the abortion laws ever since, tinkering around the edges here and there. And one of the cases where they did this was Planned Parenthood v. Casey in 1992. And what they did was that they overturned the trimester scheme that they'd created in Roe and upheld a new framework that required women to consent to the abortion procedure. They had to notify their spouse, if they were married, of their intentions, that anybody under the age of 18 had to have parental consent, 24-hour waiting periods before obtaining, and reporting requirements on facilities. So these were all regulations that one state had introduced in Pennsylvania, and the Supreme Court said all of those regulations were fine. You didn't have to institute all of those. The states could essentially decide on their own which regulations they wanted, but that these regulations were permissible. And so it provided states the ability to regulate both before and after viability. And we've seen this become controversial recently with what's been going on in New York and Virginia with the concept of late-term abortions. And a late-term abortion is an abortion after the viability date, and it can be for a number of reasons. They are exceptionally rare and typically only performed if the mother's health is at risk, or if it appears that the fetus is in jeopardy of not being viable. And so there are fairly severe limitations on that still as well. One of the interesting things about the abortion debate is that actually very few people are on either extreme. The number of people who say abortion should always be legal is really, really small, 27%, and only 22% thought it should be always illegal. Most people are the gray, they're the middle ground. It should be legal sometimes, but not always, and there should be some regulations, some requirements. And this has implications for what will happen going forward. Your text talks about the partial birth abortion ban of 2003. That has been something that was hotly debated in the early 2000s, pardon me, but we haven't seen much enforcement of, particularly because it's very rare. But also, there have been conversations about how this could change with a different Supreme Court and with a different political structure. We know that the court looks very different now than it did even just 5 years ago, with the addition of 2 conservative justices, one who replaced the deceased Justice Scalia, and one who replaced the more moderate on the court, retiring Justice Kennedy. And so it's very possible that this current Supreme Court could very much reshape our understanding of abortion.